The Supreme Court has observed that Centre is yet to answer if it ever bought or used the Pegasus software. While the court expressed readiness to give more time to the Union government to file a detailed affidavit in this regard, Centre was reluctant to file a reply since the matter concerns national security. The court is examining a batch of petitions seeking a detailed probe into media reports claiming that over 300 phones were tapped in India using the spyware Pegasus. The court noted that while the minister had quoted NSO Group's stand in Parliament, the petitioners wanted to know what was the Centre's stand on this issue. While Centre had expressed readiness to constitute a committee of experts to dispel a wrong narrative being spread by vested interests, the court asked that how will the technical committee check if authorizations were given, and how will the committee examine contracts as well as information on a possibly used software and the method which was used to procure it. Centre suggested that the court may choose members of the expert technical committee and empower them to look into the issue. Centre also lauded the Information Technology Act which was brought in by the UPA government while terming it as a beautiful piece of legislation since it took care of such issues. Interestingly, Section 66A of the IT Act, which was used to punish social media users for offensive posts, was set aside by the Apex Court many years back. Also, Centre submitted before the court that anyone can say that their phone is being tapped. However, if at all any tapping is done, it is done for national security. Last month, Union Minister for Railways, Communications and Electronics and Information Technology had told the Parliament that the news reports on Pegasus themselves clarified that the presence of a number of a so-called leaked database does not amount to snooping, calling Israeli cyber intelligence firm NSO Group's Pegasus software as an assault on privacy and dignity of a democratic republic. Petitioners before the Apex Court have sought a detailed probe into what they term as an illegal penetration into the national digital backbone. Referring to a petition filed by WhatsApp against NSO Group in a Californian court in 2019, petitioners have submitted that the messenger service had claimed that NSO had planted spyware in the devices of over 1,400 WhatsApp users across the world. Claiming that Centre had admitted in Parliament that the rogue spyware was infiltrating Indian phones, petitioners have sought a reply from the Centre on whether the software was bought and used by the Indian government. Petitioners have contended that the United States and France had already initiated action based on credible reports of spying via the Pegasus software, which has led to complaints and action by the Israeli government against the NSO Group. However, in Parliament, the Indian minister had also quoted the NSO Group, which said that the list of countries shown using Pegasus is incorrect and many countries mentioned are not even their clients. Claiming that even NSO had rubbished the claims made in the report, he added that any form of illegal surveillance is not possible with the checks and balances available in Indian laws and given its robust institutions.